My name's Caroline Drummond. I am a Scottish Law Commissioner. I am dealing with the project on commercial leases. In response to our consultations for our 8th and 9th programmes of law reform, we had submissions from a lot of solicitors, surveyors and general business people saying that the law and practice in relation to the termination of leases was a problem and they would like us to look at that and consider reform. So we've done that, and we've recently published our paper on aspects of termination of leases. Now, my background is as a solicitor in private practice, where I worked for 34 years, and so I have a fair amount of experience of commercial leases myself. So we've tried to come at this paper from a practical perspective. We've dealt with 6 topics in the paper: tacit relocation, notices to quit, apportionment of rent, the Tenancy of Shops Scotland Act 1949, irritancy and confusio. Now, 4 of those aspects are of more general relevance to practitioners, 2 of them less so, but I would just like to run through what we are proposing in the paper, and what we really need is feedback from you to the discussion paper itself. We really need to get your thoughts. It's very important that we get the thoughts of solicitors, surveyors and people at the coalface of leases. So the first topic we considered is tacit relocation. That, of course, is the Roman law doctrine which ensures in Scotland that unless you serve termination notice in advance of termination, and mostly 40 days in advance of termination, the lease will continue. That is not a concept that is known to all business people, and representations have been made to us that this is unfair and it is trapping people into an extra year of a lease where they would not have been trapped if that was not the case. So we have looked at the doctrine of tacit relocation, and we've discussed it in the paper, and we have put forward a couple of proposals for reform. The first would be to abolish tacit relocation insofar as it affects commercial leases. The second proposal is simply to give people the clear right to contract out of tacit relocation. So we would be very keen to hear views from practitioners and people in the business community as to how they think this might work and which option they might prefer. The second topic we address is notices to quit. Notices to quit affect all solicitors and indeed most surveyors, and they have become a problem because there seems to be a need to instruct solicitors on notices to quit to ensure that they're done properly. There is a fear that the 1907 Sheriff Court Scotland Act applies to all forms of notices to quit, which we have argued in our paper is not the case. We have put forward various suggestions on notices to quit moving forward and how they might evolve for commercial leases and what essential elements there should be and how easy they could be to draft. So the effect of our paper is to try and make it easier for people to serve a notice to quit. Of course, the whole chapter on notices to quit relies heavily on the response to the tacit relocation chapter beforehand. The third topic we deal with is apportionment of rent on early termination of lease. I'm not going to go into any detail on that because it's quite a specific circumstance in relation to break clauses, and I would recommend everyone reads chapter 5 of the discussion paper. Our fourth topic is the Tenancy of Shops Scotland Act 1949. That act was brought in after the Second World War to protect small shopkeepers in town and city centres. it has been put to us that the Act is no longer fulfilling that purpose, and indeed has not been fulfilling that purpose for many years, but rather it is now being used by national retailers to persuade landlords to give them a better deal when they're looking for a renewal of a lease or looking to move to different premises. We are suggesting that the subject up for discussion is that we completely repeal this Act because it isn't performing the purpose for which it was put in place, nor in fact does it protect subtenants. So we would be interested to get views on that. Topic number 5 is irritancy. In 2003, the Scottish Law Commission produced a report on irritancy in leases. It was submitted to government, but the government have not taken it forward. Because of this, we've put a chapter into our paper which runs through, very briefly, the 2003 report and reminds people of the recommendations we had made then. And we simply ask, is there anyone out there who wishes reform of irritancy, or is everyone content with the way it operates at the moment? The final topic is confusio. Now, confusio doesn't just apply to commercial leases, it applies to all leases, but it is a subject that is of more limited relevance. It tends to affect practitioners who do large commercial developments where there is a complicated leasehold structure and where at certain stages the interest of the landlord and the tenant comes to vest in the same entity. We simply ask in the discussion paper whether the law is clear or whether we should be giving a clear statement of the law, and we'd be very interested to get practitioners' views on this. Timetable-wise, we published our discussion paper in May, and the consultation period closes on 14th September. It would be very helpful if people could make any submissions to us by that date.